High-profile trade secret theft results in 18 months of prison time for self-driving truck entrepreneur Anthony Levandowski. We're here with Todd Bailey, Chief IP Officer and General Counsel at Scale AI, to talk about the theft of trade secrets. This is stuff you should know about IP. Tom, tell us about Anthony Levandowski and this story. And what exactly happened here? How did this guy get 18 months in prison?
Yeah, this is really a cool case. I mean, we've done some pretty boring podcasts, Ray. This is not one of them. One reason is we got Todd with us. No, we got Todd with us, which totally steps up our game.
I know.
But here's the thing. This is why this case is so kind of fascinating. So there's this guy, Anthony Levandowski, and he's got a partner. I think his name is Leo or Ron. And so Levindowski and Ron are working for Google, Alphabet, right? And they have an autonomous driving unit called Waymo. So they're working there like 9 years. And then in January of 2016, or sometime before that, they depart and they start a company called Automodo LLC, or Otto. So, and by the way, when they depart, they don't just leave. They leave with some stuff, because you can't just leave your employer. It wouldn't be a great story. They leave with at least 14,000 records and a whole bunch of employees, okay? So they leave in January of 2016. They form Automodo. I want to emphasize that because we're going to hear about Otto Motors in a second. But so Automodo LLC, Otto, starts in January of 2016, and then Uber is like, oh my God, I got to get me some of that. So they buy Automodo in August of 2016, and that's when the firestorms start, okay? Because keep in mind, autonomous vehicles, this is a pretty hot area right now, right? And
sign me up. I want one. I'll be the first.
I do too. I would love to have a self-driving machine so I don't have to deal with the stress of driving anymore. But that's because I'm 56. If I were 19, it would be just the opposite. But anyway, so as soon as they buy it, bam, they get hit with a Canadian company called Otto Motors, which is an autonomous driving company, for trademark infringement. And they're forced to retire the name Otto, okay? So right off the bat, they lose Otto. But that's not all. That's just the beginning. Because then Waymo does a little whammo on Uber, and they hit them with theft of trade secrets. And that case actually goes to trial. They're 5 days into the trial in February of 2018, and Uber settles for $244 million, okay? But that's not all. Waymo's Levindowski as well, they sue him for unfair and deceitful business practices for poaching all these employees. They get a judgment or a verdict. I don't know whether it was a judgment or verdict, but for $179 million, and that puts Levandowski into bankruptcy, personal bankruptcy, right? Now, this is a hotshot. Levandowski is a bright hotshot, and all of a sudden he's in a world of hurt, right? Then that's not all, because the Northern District of California wants a piece of Levandowski as well. And as you mentioned at the outset, they go after him for trade secret theft, because he steals like 14,000 records. They hit him with 33 counts of theft of trade secrets. They finally settle with one count, one document, I think. Todd, you could correct us, but I think it's one document. Yeah. And he goes away for 12 months to a place that I never want to be, right? At 5'7" on my best day, 160 pounds, I do not want to be in prison. And Levandowski,
orange is not a good color on you, Tom.
So he'll do a little better. He's like 6'3" or 6'4", and he has a full head of hair. So he's got all the advantages.
You know what, Tom? I don't think it's your height that's going to get you in trouble in prison, by the way.
Right. That's just only one of many problems. So, Todd, what are you thinking about this?
Yeah, it sort of blows your socks off when you hear that this guy left with that many documents. You gotta think about what was he thinking, and but trade secret cases like this, when you sit back and think about them, you hear about hacking and foreign state actors, and you think that's what the story of theft of trade secrets is about. But it's usually employees, it's usually failed partnerships, because these are the people that know where the good stuff is, right? And sometimes they don't know that they shouldn't be taking it either. I mean, it seems inconceivable that someone could leave with that many documents, right? But
it does. It seems like a lot of documents, Todd. Is it a lot? I mean, is 14,000 documents a lot?
You know what? I think when you're Uber, when you're Google and you're bringing suit, I think you count in a way that makes the number sound high. But for sure, it was not. It wasn't a onesie or twosie.
Right.
And the whole thing about it is that what was going through the guy's mind, right? So, but when you hear the story about in the end it was one document that they that sent the guy to prison, should he have just taken one less document and he would have been clear?
Yeah,
probably not.
13,999 and he would have been home free.
They were okay, right? But no, it's not like that. I mean, you know how it is with especially with criminal prosecutions like this was. They focused on the case that they knew they could get. That was the one that maybe Levindowski didn't have a good defense on, and so they settled on that. But at the end of the day, the guy took a bunch of stuff. It's hard to know what was going through his mind, but it's not always clear. It's not always clear between employees. Like, people think, well, I worked on that project. Those were my ideas. I can take them with me, right? That's my stuff. It didn't, and they maybe forget that they signed an employment agreement that said, that the IP that they create and contribute to is owned by the company, or maybe they signed it, but they didn't really think that was fair. Who knows? I mean, you can only guess after the fact what's going through people's heads, but it's almost always employees in these trade secret cases. It's almost always.
What do you think about Levindowski? So, I mean, this guy, so he testifies at his sentencing hearing and he's humiliated. What do you think are his prospects for getting a new job? I mean, he's a brilliant guy, obviously, in a hot area, but who would hire the guy knowing that he stole trade secrets and now he's a felon for doing that? Would that be hard for him?
Well, absolutely, it would be. Absolutely, would be. And I don't know the guy, but I think it's maybe he's the one that's been the focus of the prosecutor's case. He's been the focus of Google. Definitely, people wanted to make an example here, but is he so much worse than a lot? I mean, there's a lot of other cases out there about people leaving. There was a high-profile case between Jawbone and Fitbit. Bunch of employees left and were supposed to have been taking documents. There was another big one with Huawei where someone left Huawei and a couple of days later started a new company. And this stuff happens all the time. So would somebody want to hire him again? Well, that's a question. And employers are all the time, taking, hiring from competitors. And it's a high risk game. You hire from some competitor and you put them in the same role that they were at the competitor. I mean, you're setting yourself up for these things. I'm sure there's people that want to hire him because he's probably pretty good at what he does. And some people will say it's worth the risk.
The thing that people don't understand, I think, so Levindowski and Ron, and there was like two others that were part of the main crew, they might in their head think, hey, this is our stuff. We developed this. What people don't understand, I don't think, maybe they don't get their head around it is they're at Google for 9 years. Google is paying their salaries, their benefits, all their stuff, their lab, they're giving them vehicles to drive and stuff, and they figure this stuff out on Google's dime. Now, Automoto, by the way, was not developing autonomous vehicles. They were developing kits to retrofit trucks to become autonomous vehicles. And the funny thing is, maybe not funny for Levindowski, but the way that this came to light is Waymo gets an email from a supplier of Waymos that inadvertently copies Waymo in when it was supposed to go to Levindowski, and it has a sheet of all their, let me see, I have notes around here. They have their LiDAR technology. It's got their specifications for it, and they're like, wow, these look really like our trade secreted specifications. And that, launches it, that gets it really going. That probably gives them their first real bite of proof, right?
So they only found out by chance, is what you're saying.
Well, I don't know. They might have found out when they started seeing retrofitted trucks out there.
Right.
But this
Yeah,
is
I mean,
like the silver, or this is like the the silver bullet in the case.
Yeah.
yeah, they say
Gun.
where there's smoke, there's fire, right? So
Yes.
they may have sensed something before, but they didn't have that sort of the silver bullet or the smoking gun, as you say.
Yeah.
And
Right.
that was the piece of it. But the other going back to the other 13,999 documents,
Yeah.
In the press and for us when we're talking, as a shorthand, we talk about theft of trade secrets, but it's really the misuse of that information, right? It's not a theft, like a theft of property, it's got to be the misappropriation or the improper taking, plus then they have to show that they were actually used, and that's a thing that is sometimes harder to prove, when especially that's why there's not that many criminal prosecutions when it comes to this stuff as well, right?
Oh,
So
right. So if they take the material, but the damages occur when they're utilized.
exactly,
Right?
exactly.
And the fragility of trade secrets is the problem here, because
Yeah.
once they're out there, they're out there. It's not just the competitor, but who knows who else gets it,
Yeah.
Yeah. Once
Well,
that
and
out.
I mentioned a moment ago a Huawei case, and actually the court found that this person who had left the company to start a new company had actually taken Huawei secrets, but because they weren't used, there was no damage, and Huawei didn't get anything out of that case because so it's not just the taking, it's the taking and the using that's the problem. But
unless
actually,
unless they
sorry?
unless the stuff it's still out there, right?
Yeah.
That's the problem. Is okay, there's no obvious damage, but will there be?
Yeah, that's it. It's a more proving on the sort of misappropriation infringement side of this particular aspect of IP can be much more complicated than some of the other areas of IP.
Yeah.
That's for sure. That's for sure. And in fact, a lot of people don't even really recognize protecting trade secrets, protecting proprietary or confidential information as even a kind of IP protection. And it's really like, I think of patents and copyrights as stuff as sort of like the tip of the IP iceberg, and really all of that stuff below the waterline. And it's certainly in any technology company, this is the most important way that most of the information in those companies is protected is this way, right?
Yeah, with trade secrets, and it's a little
yeah.
fuzzy, right? When I was like a 1-year lawyer way back when, way too long ago, and somebody mentioned trade secrets, and I thought, what is a trade secret?
Yeah.
I'm a lawyer a year into my practice. Now, I wasn't an intellectual property lawyer then, but it was kind of fuzzy. I thought, I'm not even sure what a trade. I think it's just a secret, right?
Yeah.
It's an enforceable secret. That's the key thing, right?
Well, yeah, the way I like to describe it, it's information that's not generally available to the public, and it's something that you take reasonable measures to protect, right? And that's essentially, whether you're talking about trade secrets or proprietary or confidential information, those are sort of distinctions that matter to the lawyers, but to the average day person, an engineer or a software developer or anyone else in technology, it's all about secrets, like you say. And it's all about
as chief patent. You were the patent counsel at UTC Canada, right?
Yeah, Pratt and Whitney Canada. That's correct.
Yeah, Pratt and Whitney Canada. What did you have a program in place to protect trade secrets? Processes, technology, that sort of thing.
Absolutely. Again, so I'm up here in Canada, and there's not so much a distinction up here between sort of regular proprietary information and trade secrets. But to me, even as a company, again, those are things for the lawyers to argue about later, but about protecting information, absolutely. You need to have a program, and a cornerstone of that program starts with training people so that, they understand, it's definitely like a weak link theory for protecting information. You're only as strong as your weakest link. And so your people that are handling information every day, they need to understand that they're handling something important, that each, it can be death by 1,000 cuts in a technology company, right? Each little piece you lose is something that it doesn't hurt, as you're losing it, but it starts to really mount. So, you need to, training is super important, and, training people in a way that they can understand in everyday language and that sort of thing, is really important. And I know you guys know that at Executive IP, that's for sure.
Yeah. We were hoping you'd say something about the value of
Preach,
training.
preach.
Yeah. Well, and that's, that's you were a big part of our training program up there, and part of what was effective is your ability to deconstruct complicated ideas into simple things.
Yeah. So
because when it comes to protect,
what would you have done if you were if you could go back in time to, I don't know, 2015, and you were the chief patent counsel at Waymo? What would you have done? What could they have done to see this coming and prevent it?
Well, I think the first thing that at Waymo, so they lost the employees, right? And I think it's really essential to have employers do exit interviews with their people leaving, when it's possible. Sometimes not possible because they go home on Friday and you never see them again. But for sure, exit interviews to say, hey, look, this is, you worked here in a high-tech area. This is, everything you generated belongs to the company. It's not free for you to take. It's not stuff that you can use. And, by the way, here's your employment agreement that you signed. Remember those obligations in there. Because I think, a lot of employees, I saw a survey recently that done by a security firm that said about 75% of departing employees take information from the company when they go. So this is not just a Anthony Levandowski problem. This is, people do this, right? So poor Mr. Levindowski got caught bad, but
because stuff that mattered, right? Like, if you're in anything, if you lose, no one cares. When you win, everyone cares. Levandowski took stuff and then won. That was his flaw, right?
Yeah. Well, that's it. And he it was very high profile, and there was some, mistakes that were made and so on. But the mistakes happened back when he took the stuff and felt that he had the right to take stuff and all that sort of stuff. So, that exit interview, you can't take stuff with you. Where are you going? That sort of thing. That's what I would have done. If I was on the other side at Automoto or eventually Uber, I would have, you got to have a program where you say, you're coming from, I don't want you to bring any information to this job. Okay. I don't want that problem here. We want the goodness in your brain, but that's sort of like, the math and science and technology and experience, not what the other guy was doing.
Right.
And, then you can't tempt fate. You got to put these people into different roles, different sort of, you can't take them ahead of automated driving from one company and make them ahead of automated driving, because it's just, you're playing with fire. You're playing with fire.
You are so right. And I was also thinking, as you're talking, Todd, it might also be good to kind of keep your fingers on the pulse of your employees.
Yeah.
Number one, if they're happy, they probably won't depart. Although this guy really wanted to get out and build his own enterprise, and he's in a place that's very entrepreneur heavy, right? He's in the San Francisco area. But two, you download, I guess it's not like you're downloading 14,000 records all at once. It's probably on your computer, right? I mean, it's on your
phone or phone, your iPad. Like that's part of this, right? Like we don't know all the facts. Like the guy could have just left with his iPad and I didn't know I had those 14,000 documents. Possible, right? So
right, or particularly that one, right?
Yeah.
But the other thing is, if Levandowski's he takes all these people, they have all the brains to do this. It makes you wonder why they needed to take all the documents as well. I mean, you got all the people. Maybe you lose, I don't know, 3-4 months.
Yeah, I was reading. I mean, a couple of the documents were just project plans, like 3 months to do this, 2 months to do that, and the different working pieces. These weren't the scientific or technical documents about the AI algorithms that were involved. I mean, some of them probably were, but some of the fundamental documents that were central to the case were like project management stuff, and who knows.
In your head, like if you could recreate, let's just say, all 14,000 documents from memory, or the basic concept of them, and then get a new team of engineers, some of whom I guess were the same people, to recreate that technology, is that still trade secret theft?
That's still trade secret. That's still trade secret theft, but it's not as tangible and visible as 14,000 documents.
Right.
For sure.
You're
For
still
sure.
committing
Are
trade
obvious,
secret theft. But, ultimately, if you leave your company to go and start a competitive company, you're going to have problems, right?
Yeah.
I mean, if you have a document signed or if there's trade secrets, I don't care if you took 14,000 documents or took 0 documents. If they have enough money, they're coming for you.
This is where most of the trade secret cases come from either employees or failed partnerships or sometimes customers that decide they want to get rid of that supplier and either reverse engineer the thing and do it themselves. This is where almost all the cases come from broken relationships. And if you're going to do that, you're heading into a real swamp if you just think that you can open up shop the next day and keep using all the documents, the tools, the same people doing the same things. I think it's the only difference between the successful cases and the ones that aren't is just who gets lucky in getting the best evidence to prove the smoking gun, as you said.
Yeah, and ultimately, I'm not just saying this because we have a training company, but I think training is the critical piece, because if Levindowski could see the future, he might not have done this. If he knew he was going to end up in jail for 12 months and have a $179 million verdict against him and go bankrupt over it, he might have come up with another way. He might have eased his way out of Waymo, made a deal with Waymo, set up a subsidiary with Waymo. I'm sure they would have loved to have a subsidiary like this.
Yeah.
Comes down to training. You got to scare the you-know-what out of your employees and let them know, here's what could happen. This is the ghost of the future.
Yeah, I mean, it's tongue in cheek. You got to explain to them first, and I know that's what you guys do well. And scaring them by helping them understand, not to scare them for no reason, but to help them put them in the shoes of these cases, right? I think the stories matter in the cases whenever you're trying to help people understand. IP is complicated, and a lot of people just sort of they don't have the courage to dive into it. So if you can tell it through stories like cases like this, I think it's really important to help people sort of see how it applies to them or what it looks like in real life.
Well, the message I'm taking away from this, Ray, is we got to make a video on this story.
Yeah, we should do a podcast. Wait a minute.
No, we're gonna shoot a training video on this story, a scenario video, right?
Yeah, I think it's a great
story.
Absolutely.
Yeah. Story. All right. We're gonna shoot it next Saturday because I already pretty much did all the research for it.
Awesome.
All right. Good.
Yeah, I'm stoked. Yeah. Well, this has been a really informative discussion, and I appreciated the trade secret theft and how this kind of thing commonly happens has been something we've been wanting to talk about. So I'm so glad that we got to reconnect, Todd, and I hope that all of you guys enjoyed this conversation. If you're interested in learning more stuff you should know about IP, go to the Stuff You Should Know About IP YouTube page and hit subscribe. And if you like this video, don't forget to share it and comment, share your thoughts. Thanks, everyone, for tuning in.
Thank you.